Good morning, everyone. Deputy Registrar, can you please commence the proceedings?
Thank you, President. Good morning. Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of the Eastern Caribbean Supreme Court, St Lucia, hearing of appeal in CCJ Appeal LCCV number 2 of 2024 between Peter Hippolyte, Michael Augustine, Martinez Alexander, and Magistrate Bertlyn Reynolds and the Financial Intelligence Authority. The members of this morning's panel are Mr. Justice Saunders, President and the Presiding Judge.
Good morning, everyone.
Mr. Justice Anderson.
Good morning.
Good morning, Counsel.
Madam Justice Roch North Lee.
Good morning, everyone.
Mr. Justice Barrow.
Good morning, all.
And Mr. Justice Jamadar.
Good morning to everyone.
May we have the appearances, please? Thank you.
May it please Your Honors, Horace Fraser appears for the Appellants. Present on the platform is Mr. Peter Hippolyte and Mr. Martinez Alexander.
Yes, good morning to you, Mr. Fraser.
Good morning.
And to the respondents.
My name is Savioja Snack. I'm a senior Crown Counsel in the Office of the Attorney Generals, and I represent the respondents in this matter. And appearing with me is my learned colleague, Mr. George K. Sharmine, also a Crown Counsel, representing the first and second respondents. Appearing on behalf of the second respondent, the FIA, is Ms. Casey Ogis.
Yes, thank you, Mr. Snack. Are you ready, Mr. Fraser?
Yes, please, Your Honor.
Yes, please proceed.
Your Honor, I will only make brief reference to the written skeleton submissions when the need arises, but I would not endeavor to repeat anything that I have in those submissions. I believe the starting point, Your Honor, is the proper construction of Section 29A of the Proceeds of Crime Amendment Act number 14 of 2013 as regards what the police officer or the investigator who is attached to FIA must prove before the magistrate on an application for a continuing detention order. And one of the things that must be proved is the seizure. The seizure is important because it starts the clock running, so to speak, in relation to the 72 hours of observation to accommodate such an application. So the seizure in itself must be lawful and it must be valid. The importance of the seizure is a declaration by the public official to the owner of the property that that property will not be available to the owner for his use or disposal for a period of time. So it's critical that the owner's involvement and his knowledge of the seizure must be brought to his attention.
Mr. Fraser, as you go along and you make your submissions, could you kindly tie it all in with what you really brought before the court, which was a judicial review application, so that we could look at what principles should be applicable even as we examine the legislation and the requirements under the legislation? I'm sure you'll get it. I saw it in the Court of Appeals judgment as well, how they treated with the fact that this was a judicial review application. Thank you.
Yes, sir. Yes, sir. So on that score, Your Honor, the learned magistrate was required to make the determination of the continuing detention order in the four corners, within the four corners of Section 29E. And one of the principles or one of the factors to look at is the question of the seizure. As I said, because it sets the timetable in relation to the section 72 hours, which is required to accommodate the application.
So what is your complaint about the seizure?
Our complaint about the seizure is twofold. One, there was no seizure. So it did
you
not
have
trigger.
The property? The appellant has the property?
The property is in the bank and has been in the bank throughout the period when the officer said that she seized it. And herein lies our difficulty.
It was in the bank, and who had custody of it? Who had effective control of it?
Control of it was in the hands of the police officer, the commissioner of police.
Mr. Fraser, since you're making a highly technical point, you said the money was in the bank. Was it in a bank account or in a bank safety deposit box?
Yes, please, Your Honor.
Yes, please, what? Which was it? Bank account or bank safety deposit box? What?
It was in the bank's vault. During the time of the criminal process.
From 2010 to 2025, it has been in a bank vault, correct?
Has been in a bank vault, yes.
Thank you.
So the contention of the appellants before the court was that at best, what the officer had to establish before the magistrate is that she effected a constructive seizure because she had no ability to physically seize it. And our contention was there was no evidence at all as to what she did to effect a constructive seizure.
Who would you say had possession of it at all material times?
The police, commissioner of police had possession
of
the rest.
You're saying Officer Jules never had possession of it?
He never had possession of it. And when she said she seized, she could not have done so physically because it was not available for that.
Yeah, but did she need to do so physically in order to be able to establish that she had seized it?
No, my lord. Your Honor, as I said, we accept that the seizure had to be constructive.
Mr. Fraser, sorry.
Go ahead, Justice Barrow.
Yeah. Mr. Fraser, I see where Jules says that I formally seized the cash from Corporal Alan James.
Yes, that is what she said.
If Jules were to say to James,
oh, you're gone on mute, Justice Barrow.
Sorry, there's some construction going on. Let me just stop it. Just give me 1 minute, please. Sorry about that. Yeah, Mr. Fraser, if Jules were to say to James, I am now taking over this matter, the seizure of this money. I am now taking possession from you. And James says, yeah, that's fine. Here are the keys to the vault, or you can go ahead anytime, etc. What stops the magistrate from accepting that that was a formal seizure? The person who has constructive control of the money, given that there is a physical control of the money, the person who has control of the money says to another person, here, you take over, or yes, I accept that you now have control. What stops the magistrate from making the decision that there has been a seizure. The question is not whether the magistrate is right or wrong in making that, but what stops the magistrate from deciding that that can amount to seizure? Help me, please.
Because, my lord, it has been accepted that seizure is a formal act. And that comes out in the case of Iqbal and the case of the Queen on the application of Kingdom Corporate Limited suggests that it's a ceremony. So the mere fact
so Mr. Fraser, one police officer to the other says, boy, I'm taking over. And the police officer who has custody says to the other, girl, go right ahead. What else is required?
That is not a formal seizure, my lord. There must be something more. And the parties who are supposed to have the possessory right of the res is not even in the picture.
You said, Mr. Fraser, that more is required. Did I hear you right?
Yes, more is required.
Tell us what more. Yes, thank you.
Because in compliance with the statute, the magistrate had to be satisfied that there was, in fact, a seizure. You can't just come and say, yes, there was a seizure. The magistrate has to be satisfied that, yes, there was a seizure.
But if the officer James says, I was relieved of the constructive control by Officer Jules, why isn't that a seizure?
But the thing is, Officer James never said anything. It is Constable Jules making all the statements. She alone, and all she said.
But do you have evidence from James that that was not done?
There was no evidence produced from James to indicate anything.
So there was no evidence to contradict Officer Jules when she said what she said. And therefore, the question is, does what she said sufficiently constitute a seizure in the absence of anything to the contrary?
We say because the Crown has the duty to prove legality, Officer Jules just simply cannot come and say, simpliciter, I formally seized the currency from James.
But Mr. Fraser, the point made by my sister, I think, looms so large.
Yes.
These are JR proceedings. You are going into the merits of the magistrate's decision as to whether a fact which she found had been proved was not proved. You are dealing with the merits and not with the rationality of it. You are saying, you need to say that it was an irrational decision.
Yeah, that is what we're saying, my lord.
That's what you're saying, but go right ahead.
We are saying based on what the statute requires. The magistrate does not satisfy herself that they came within the statute.
No, Mr. Fraser, you need to do more than that. You need to say it was irrational or unreasonable.
I take the point.
So you are saying it's irrational?
That is irrational.
Well, you have totally lost me, Mr. Fraser.
To act on the evidence.
I have looked at what Colombo says. I've looked at what Jules says. I have looked at what the various persons have said. And I confess you have totally lost me. So if you can bring me along, I'll be deeply grateful.
Yes, Lord. Your Honor. So the contention here is simply this. It was not reasonable for the magistrate to accept that there was a seizure in light of the evidence before her.
You know, Mr. Fraser, Justice Rationally asked the question, what more would you require to support the idea that there was a seizure? I'm not sure I got a clear answer to that question.
That we needed something more.
Yes.
To indicate that a seizure actually took place. Apart from saying that, what did you do? As the Court of Appeal said, at paragraph 28 of the thing. She did not give any details as to what seizure entailed.
Well, you still have not answered the question. Well, with respect, I don't know what more it is that she needed to have done. The Court of Appeal did say, while she did not go into details as to what that seizure entailed or how she went about it, the learned magistrate was clearly satisfied upon hearing WPC Jules and reading her affidavit that she has satisfied the necessary conditions of seizure to warrant the grant of the continued detention order. So, obviously, the Court of Appeal thought that the magistrate was acting within the bounds of rationality in finding that what the constable had done satisfied the definition of seizure. And we are trying to understand from you, well, you said something more should have been done, but you still haven't told us what that more is, and that would be helpful if you could.
I thought I mentioned that, Your Honor. I thought that a notice, I made the point that a notice should have been given to the appellants at that junction. A notice, some form of notice.
A notice that the property had been seized.
That's been seized.
Right.
Because it's a declaration that they're no longer able to deal with the property.
Mr. Fraser, they were not able to deal with the property since the property was seized. Come on.
But Milord, it was always available to them to make an application for the release.
Right, application.
So if the property is seized, they know they cannot make that application.
Right.
And so it would have indicated to them that you are no longer able to deal with this property or to dispose of it in any way. And that means you couldn't even make an application for the release of it.
But they didn't make any such application.
Can I ask? Sorry, President.
No. Go ahead.
No, I just want to clarify. So is it then that what you are telling us is, but for the failure to serve the notice, that there is nothing more that needed to be done? My understanding of what you're saying is quite simple, I think. You're saying that no tribunal properly informed on the facts could have rationally come to a conclusion that there was a seizure. Whether you put it on the basis of rationality or Wednesbury unreasonableness, it matters not. Basically, you are saying there is no factual substratum for a conclusion that there was a seizure, correct?
Correct.
Right. And is it that deficit lies only in the failure to give notice? Is it the failure to give notice? Is it that is the only thing that makes it irrational or Wednesbury unreasonable?
That is key to it.
When you see, you cannot answer. I think Justice Anderson was trying to get this from you. You have to be precise. That could be one component. Okay, is there anything else? Justice Rajasli asked you anything more. If you don't give us the detail now, how are we going to go along with you?
My Lord, we're saying that at least a notice would have been given, and that would have satisfied the law in relation to constructive seizure.
And the failure to give the notice rendered the decision Wednesbury unreasonable.
Unreasonable.
All right.
The difficulty I have with that, Mr. Fraser, is that if you concede that the notice was alerting them that there had been a seizure, that a seizure had been effected, then it means that
seizure had been effected.
The seizure had been already effected. And that the notice was not a component of the seizure, but an alert that the seizure had taken place.
And in any event, that alert must have been given at the point at which there was an application for the detention, which was what, a day or two later?
That is correct, Your Honor.
So, and that took place, what, 2 days later?
There was no notice of a seizure. This information of a seizure came in the process of the application 2 days later.
Right.
And that is, Mr. Fraser, what the law provides.
The law provides that when the application is made, there would have been a seizure at the point of the application.
No, I was talking about notice. I'm sorry.
Yes.
And the law provides that within 72 hours.
That is correct.
That application should be made.
That application should be made.
Yes, but according to how we see, at least I see 29A of the poker, it does appear that the seizure has taken place.
A seizure has taken place. So there's a seizure and then there's the application.
Right. So you have no problems with the application. Your point is that there was no seizure. The application, if you concede that there was a seizure, the application for the detention would have been regular, right?
No, but that's a different question. We are also questioning the legality of that application.
Ah, oh, I see.
Because we're saying the 72 hours was not factored into that application at all. It was way up past 72 hours.
I see. But you're going to come to that, no doubt. I don't want to distract you. Yes.
I can move on from that question and move on to the next issue, is that the seizure was from an unlawful source. And we shall rely on the arguments set out in paragraph 2.5 of the submissions, that after the discontinuance of the criminal proceedings, the police failure to release the currency to the appellants and choose to decide what to do in the interim, which took 115 days, was abuse of the process and was beyond the 72 hours required for the application. We are contending that the Lord Trial Judge's findings of paragraph 98.
Mr. Fraser, I don't want to interrupt you, but I'm a little I'm confused. Are you conflating something here?
Yeah.
Because it's 72 hours. Just to take a step back, the seizure in this case that is supposed to trigger the 72 hours, and I take your point, you say there was no seizure, I get that, but the alleged seizure that was supposed to trigger the 72 hours was a seizure, the alleged seizure by Jules, correct?
Correct, my lord.
Right. Did Jules come for the detention hours within 72 hours of her alleged seizure?
We're saying this, Your Honor.
Mr. Fraser, please just try and stay with me. I understand what you're saying about the seizure by Jules. We've covered that ground. I'm on a time issue. If you assume that what Jules did was a seizure, I know you're saying it wasn't, but if you assume it, did she approach the court for the detention, the magistrate detention order, within 72 hours of that occurrence?
This is what the case for the respondent is. This is the case that the Court of Appeal accepted.
No, I'm not asking you that. I'm asking you a question of fact. It's a question of fact. Either the facts support it or they do not. If it's a hypothetical, if, Mr. Fraser, if the seizure occurred as Jules said it did she come for the detention order within 72 hours?
That would have been the case, my lord.
Yes, okay. But
that would have been the case.
all right, so
but the argument
you put in the beyond 72 hours in what you just said, and that's what confused me. You are saying the seizure was from an unlawful source. After the discontinuance of the criminal proceedings, the police failed to release the cash, an abuse of process, and beyond the 72 hours. I don't understand why you have 72 hours in that sentence or in that thought. That's what is confusing me.
Yeah, if I can clarify the point. We are saying that this seizure, this purported seizure, was from an unlawful source, an unlawful possession. And so therefore, it could not have triggered the time which was required, that is the 72 hours. And that period of 115 days is what we straddled with because it's unlawful. So the 72 hours is by way of reference, but we're saying that seizure could not come from an unlawful source. And that is supported by the authorities which we put before the court. And that is what the learned trial judge found at paragraph 98 of the judgment.
Just to clarify, Mr. Fraser, is that then the second ground of the appeal that you have put forward before us?
No, that is not the second ground. I haven't gotten to the second ground yet, even though it overlaps with what I'm saying here.
Yes. Okay.
It overlaps somewhat.
Okay.
The Court of Appeal found that the trial judge's reasoning at paragraph 98 was an error. And the Court of Appeal at paragraphs 49, 50, and 54 accepted the findings and reasons of the learned magistrate, relying on the cases of Marcel and Iqbal.
But the problem with the Iqbal case, wasn't it the case that the original seizure itself was unlawful? You're not contending that the original seizure in this case was unlawful, are you?
No, Iqbal's seizure was lawful. And a mere 7 days after, there was a re-seizure.
Right.
Well, what we're looking at is that
but what I'm saying is that in Iqbal, is it Iqbal? Wasn't it that case which held that the re-seizure could not be allowed because the original seizure was unlawful?
No, that's not Iqbal.
That's not Iqbal. That's probably Cook. Is it Cook then?
That's Cook.
Yes. 2011.
So the reliance in Iqbal and the reliance on Marcel, that the documents could be held, that the rest could be held as long as necessary in all of the circumstances, is an interpretation of Section 22 of PACE, which specifically says that. And the Court of Appeal accepts at paragraph 52 of their judgment that PACE is really a codification of the common law. If we accept that reasoning of the Court of Appeal, it means, therefore, that Malone and Ghani are still much the law. And that as long as necessary does not mean you could hold it for whatever reason without justification, and you can't hold it as long as you think you can hold it. Those cases do not support that proposition.
So, Mr. Fraser, in this case, your point is that the moment the original criminal proceedings were discontinued, is your point that at that moment, continuing to hold on to it was to do so unlawfully?
No.
No, because based on what you just said, the police could have continued to hold on to it for a period of time, reasonably so. Agreed?
I will say two things in answer to that, Your Honor. One, holding on to it must be for a purpose of some investigation that has to do with the case.
But does it have to do with the case? Is that what the case law says?
In accordance with what Malone says, it cannot be held to speculate on forfeiture proceedings. And that is what seems to be the case here, because if you look at
no, but could it
ASP
be held in relation to other possible criminal inquiries or matters?
It could be.
Right.
It could even be held to look for the owner, the real owner, so to speak.
All
so
right.
you have to.
No, I just want to stay a little disciplined. So the seizure, you see your statement is the seizure is from an unlawful source, and by that I think you mean when the original criminal proceedings were discontinued, the status of the cash changed from being lawfully held to being unlawfully held. But at what point?
Well, I would say if we are guided by Iqbal.
Well, yeah.
Iqbal says at paragraph 26, a short period of grace. A short period of grace, even though they're interpreting section 22 of peace, it says that they could hold it as long as necessary in all of the circumstances. The court did say it must be a short period of grace and there must be an application in short measure. So at that time, the police should have approached the magistrate for a continued detention order shortly, because they received notice on the 4th of January that the notice of discontinuance was filed. But they took 115 days to get their act together.
So is that, I'm just trying to pigeonhole this. So is that therefore your abuse of process point?
Is the abuse of process point.
So your argument then is, look, they could have come, but they should have come within with what you call a short period of grace, a la Iqbal, for the further detention order if they wanted, no problem. Having waited 115 days, that is untoward, and therefore the process became an abusive process.
And unlawful.
Hence, from that, because of that 115 days, because of that, what Jules does is unlawful also.
Correct.
All right, good. I understand what you're saying. Yeah.
Just to query, Mr. Fraser, could you have applied, or your clients, for the return of the res?
They could have applied, Your Honor.
So why didn't they? If they thought that the res was properly belonging to them and there was no good reason for the police to be holding on to it for 3.5 months or whatever, why wouldn't they apply? I'm just curious.
I can't answer that, my lord.
Because that application, you see, is relevant. That application would then be preventative of an abuse that you're now alleging, wouldn't it?
It would, but you remember, my lord, the onus is on the Crown, not the appellants, to do anything in respect to the currency.
Right.
I have not come across any authority that says that if they don't apply, then there's some penalty, so to speak, that will be visited upon them for not so doing. But more so, if you look at the affidavit of ASP Collymore at paragraphs 5, 6, 7, and 8, where he chronicles what they were doing in those 115 days, you will see that there was no justification for holding the currency, for continue retaining it, that the purpose of retaining it was to decide what to do next. And even though they got notice on the 4th of January, they did all manner of things, and there was no justification coming out of that evidence to suggest that they had a right to detain it. They were not looking for the true owner. They were not looking to file other proceedings. Late in the day, they decided, let's invoke poker.
Did the Court of Appeal address that point?
The Court of Appeal says that agreed with the magistrate that the currency could be held, as the magistrate said, for necessity, relying on section 22 of peace.
Is that paragraph 54?
That's the judgment of the Court of Appeal.
Yeah, Mr. Fraser,
The
they were
paragraphs
actually
of
saying it was
ordinance.
open. It was open to the magistrate to arrive
Yes.
at that finding. Yes.
At that findings.
That
And
the
because
police were in lawful possession.
Yes. And because the magistrate was relying on Marcel and Iqbal. But as I address the court, neither Marcel or Iqbal says that. Neither Marcel or Iqbal overruled Malone or Ghani. And then the Court of Appeal said those decisions in Malone and Ghani were codified. And so to hold as long as is necessary in the circumstances has to be in light of what Ghani and Malone says to aid an investigation. And in this case, we had no investigation. All we had is a stalling to decide what to do next. And herein lies the problem. So Ghani doesn't support the conclusion, the Malone, and Iqbal does not support the conclusion which the magistrate came to and which the Court of Appeal accepted as being sound.
So you're suggesting that throughout those 150 days, or at least a portion of the 150 days, if you accept that some of them, 115, yes. If you accept that some of those days, or do you accept that some of those days were justifiable? 1, 2, a week, 2 weeks, a month? Or is it that throughout that period of 115 days, the police were in unlawful possession of the cash?
I will make a concession and go back to Iqbal and says a short period of grace could be given. And I said a short period of grace could have been 3 weeks to a month. No more than that. Anything after that, I believe, transgress the law. And this is where we are.
You're saying that, okay, if you stay a month, 30 days, 30 from 115 is what, 85? That throughout those 85 days, the police were in unlawful possession of the property, of the cash.
That is what I will say.
And what's the consequence of this? That Jules could not seize it?
Jules could not effect a lawful seizure. So it comes back to the point again that there is no seizure number 2, because that's purported seizure is not lawful.
So for her to be able to seize it, she would then have to, or the authorities would then first have to return it?
Return it and then seize.
Okay.
Sorry, colleagues, I'm at a bit of a loss here. Mr. Fraser, could you tell me which ground of appeal this is?
This is, as I indicated, the first ground has twofold on the question of the seizure. I dealt with the actual seizure itself. Now I'm dealing with the fact that the seizure was not lawful.
Yeah, but you have not brought any cause of action for an unlawful seizure. You have not sought any constitutional law relief. You have not sought anything. You have 3 grounds of appeal. One relates to costs, and the other 2 were that the Court of Appeal fell into error by ruling that the magistrate was right to accept that the seizure was effected, so in the face of non-existing evidence. And the second ground was that the acceptance that it took place within 72 hours. So the unlawfulness of the seizure, the detention for 85 days, etc., all of that, I'm afraid you have been lost. Help me, please.
I believe the question was asked of me earlier when I was arguing the second ground. And I indicated to Your Honor then that rightfully the same matter comes up in the second ground. So basically because it overlaps with what I'm arguing concerning the lawfulness of the seizure.
Because you're saying, to be fair to you, Mr. Fraser, in your second ground, that the decision of the magistrate was ultra vires statute.
Yes, sir. And that is because...
What makes it ultra vires statute is the legality point you're now talking about.
The seizure was not lawful. And so therefore, there could not be an application within the 72 hours period as is prescribed by the statute.
Sorry, Mr. Fraser, but as I understand it, you are talking about accepting evidence that a seizure took place within 72 hours. That's what you're talking about?
Yes,
accepting the evidence.
Accepting that evidence. And we're saying the evidence shows that the seizure itself was unlawful.
You're not saying that with respect. You are saying that there was not any evidence that it took place.
It might be convoluted, my lord, but the essence of what we were saying is that there was no evidence of a legal or a lawful seizure, which the magistrate could have accepted because of the circumstances.
And you did elaborate on that in your submissions. Right?
Yes, or when the seizure took place.
So I'm trying to get back to what I was asking. So how would this work? So the money is in the vault, but you're saying for there to be a proper seizure, it had to be returned to your clients and then seized from your clients. But yes, you would not need the money itself to be returned to them, would you?
No, because the cases suggest that could be done by a ceremony.
Done by what?
A ceremony.
Ceremony.
You can call them to the station and perform a seizure. Perform a return and a seizure. It was done in one particular case. And the judge called it a ceremony, where they called the defendant in, gave him a check, and then took it back. So that could have happened.
Well, Mr. Fraser, what I am, for myself, what I'm just struggling with a little bit in what you're saying is this. If you are right that the law is that upon the discontinuance of the matter, the criminal matter, right? Iqbal, the law says that the police could hold the cash for a short period of grace, whatever that works out to be. Thereafter, they must have a purpose. Pace, a purpose of necessity means they must. It must be, you say, because they intend to aid an investigation or they're looking for the owner or something, right? All right. What I want to ask you is this: if the police, in the first instance, lawfully took possession of the money in the bank, discontinue those proceedings, and do nothing, who has possession of that money as a question of law?
The police.
How? It's in the bank in whose vault?
It's in the bank vault, but remember the depository is the police, or the depository is the police.
Right, right. So that the vault, the owner of the vault is the commissioner of police.
No, the owner of the vault is the bank.
The owner, when I say the owner, the person who has, how did that money get into the bank vault?
The police took it to the bank.
Right, right. So the police took custody of the money in the first case and placed it in the bank vault for safekeeping, correct?
Safekeeping, yes.
So therefore, your clients had no access to that money in the vault.
None at all.
Right. You say that after a short period of grace, the police, their continuing possession or detention of that money was unlawful. Yes?
That is correct. That is correct.
And therefore, an independent seizure constructive by Jules cannot constitute a seizure because the money was being held unlawfully. That's a simple argument that you make.
That is the argument I'm making, my lord.
Yeah. Okay.
But you know, I wonder where we go ultimately with all of this, because let us say we were to agree with you and we were to find that the ceremony, as you put it, ought to have taken place. If the police still harbors the suspicion that in their minds, justified the seizure and the detention order, is there anything preventing them from tomorrow morning going through the ceremony and then effecting the seizure in the way that you think it should be effected?
No, that is a rank abuse of process, abuse of authority, my lord. To seek to do that now, when you had the opportunity.
No.
You had the opportunity, my lord.
What I'm saying is, if they still harbor the suspicion that the money was tainted, let's say no more than that, and they still have, as I said, maybe evidence, at least strong grounds for believing so, what would prevent them from carrying out their law enforcement functions tomorrow morning after the ceremony?
Because now we got into the area of abuse of process, my lord. And that would be the remedy of the appellants, to bring a claim for abuse of process. I think the opportunity for them, the police to do that, has failed.
Mr. Fraser, just on that point, is there any evidence? I know the Court of Appeal speaks about the facts of the case where the respondents found in the vehicle in the early hours $1 million EC. Based on these circumstances and the additional evidence of the original seizing officers, there was enough evidence for Jules to form her own reasonable suspicion that the cash formed the proceeds of criminal conduct, right? That's how the Court of Appeal justified the second aspect of what Jules did, the reasonableness, right? That's how they addressed it. Your answer is that because of the Iqbal principle, if I may call it that, if reasonable time had passed, Jules had to do something more. There had to be some justification for the continuing holding.
Correct.
So your point is that you cannot rely on if they were relying on the original justification for reasonable suspicion, which is what the Court of Appeal says, then what you say is the 72 hours can't begin to run 115 days later.
Correct.
Because the justification, as the Court of Appeal explains at paragraph 39, is the justification at the time of the original seizure. Yeah?
At the time of the original seizure, the justification was to seize the currency and in the criminal process.
No, I understand that, but is it your case that that original justification cannot constitute a continuing justification 115 days later for the purposes of what Jules did? Is that what because the Court of Appeal says that that was sufficient. Is it your case that could not be sufficient?
My contention is, Your Honor, that Officer Jules could not go back and accept the suspicion of Constable James. She had to form her own view about what she suspects having regards to what was before her. Then come to the magistrate and say, having regards to the factual matters, I now have suspicion and latent, and then make the application for the continued detention order, but it can't go back to James.
And you say she gave no such evidence?
She didn't give it. Well, she said she relied on the affidavit of James. She relied on Schooner, and
but that is evidence. That is evidence of what happened at the time of the original seizure. Is that correct?
That is what happened in the original seizure. Yes.
And then right. I'm just trying to clarify. So the Court of Appeal says that was fine. She could rely on the suspicion of others and formed her own suspicion at that time. 115 days later, are you saying that apart from the fact that she must say she formed her own impressions, had her own reasonable suspicion, are you also saying that she could not rely on what had happened 115 days before? Or could that continue to constitute reasonable suspicion for her 115 days later? Suppose she had said what you suggest she should say. Would that make it okay?
I believe in the context of Officer Jules, she had to form her own suspicion.
Okay. Yeah.
She cannot go back to James and say James is suspect, and so therefore I am accepting and adopting what James did. She had to form her own suspicion based on the factual matrix of the matter.
Okay, thank you.
Mr. Fraser, help me though. Two things. The Act 29A1 says she must have reasonable grounds for suspecting. And that is what the Court of Appeals seem to suggest, that they were satisfied that the decision of the magistrate was correct. But the Court of Appeals spent some time dealing with that matter. Is that a matter that you accepted, the decision of the Court of Appeal, or did you appeal on that ground?
I didn't challenge that because I believe its construction of Officer Jules' evidence could result in the fact that she formed a suspicion based on the circumstances of the stop, what was found, and the fact that the appellants were subsequently charged. Those are facts.
Am I reading you right there? As I don't want to misunderstand you. You're not challenging the Court of Appeals decision on that basis.
I'm not challenging the Court of Appeal on that at all.
I thought so. Thank you very much, Mr.
Yes.
Fraser.
Okay, thanks.
I believe I can move on to the second ground, and I thought that I did deal with it mostly already. By saying here,
that was my view as well, Mr. Fraser, that you have dealt with it already, but you may think otherwise.
You did make that indication, and so I would not endeavor to repeat myself. Just to say is that Section 29A of POCO does not require the magistrate to look into the reasonableness of the police conduct as it regards to the delay in going to the court for detention order. There is nothing in that statute which requires any exercise of any such discretion on the part of the magistrate. And when she embarked on that, that was a total irrational, irrelevant consideration in the matter. And again, that was adopted by the Court of Appeal. But the legislation requires simply the magistrate to accept whether, in fact, an application was made within 72 hours of the seizure of the property, and not to inquire whether the police conduct was reasonable. No authority supports that proposition.
What paragraph of the Court of Appeal are you on, so that I can follow it a little more closely? Mr. Fraser, please.
1 second, Olive.
Thank you very much.
Paragraph 50. And 54. Paragraph 50 and 54, Your Honor. Well, I now address a point raised by the respondents at paragraph 26 of their submissions. And that submission is that if the court finds for the appellant, the court should exercise a discretion, a residual discretion, to refuse to make an order to restore the res to the appellants. And the relying of the case of Goff and the Chief Constable of West Midlands. It is our contention that such a discretion did not reside at common law, and that any such procedure had to be provided by statute because the law has recognized a citizen's constitutional right to a possessory title to such property. And that was seen in the case of Taku Jaru and the Attorney General of Trinidad and Tobago, 2002. And we suggest that the authority of Goff is doubtful on that issue. I wish to refer the court to the case of Roy Webb. Page 5, paragraph 2, where that issue is addressed by Lord Justice May. He said, and I quote, Mr. Turner further submitted that the circumstances in which the proceeds of drug trafficking can be confiscated or forfeited are governed by statute. No statutory provision extends to the circumstances of Roy Webb's case. It may be thought unsatisfactory that a person who has probably been involved in drug trafficking should have returned to him the proceeds of drug trafficking. But it's not for the court to fill a gap in statutory machinery for confiscating proceeds of crime. It is no part of the court's business to sanction exploration which is not authorized by statute. And the court made a similar finding at page 12, going on to page 13 on that score. And lastly, Your Honors, the last ground 3, to say briefly that this matter involved a constitutional right, that is the right to property. And though the matter is proceeding by way of judicial review, it is nevertheless raising a constitutional point. And in that regard, I believe that the court's policy that came out of Baldwin Spencer applies to the question of cost. My friends are of the belief that it has to be out and out a constitutional motion before that policy applies. My take is that the policy also applies in public law proceedings that touches and concerns a fundamental right, as it has done in this case. So unless the court wishes to hear me on any other matter, those would be my submissions in relation to the appeal.
Thank you, Mr. Fraser.
Thank you, my lord.
Mr. Snack.
Your Honors, thank you very much. Your Honors, as you've heard, the appellants have appealed the unanimous decision of the Court of Appeal, which was delivered by Her Ladyship, the Honorable Chief Justice Dame Pereira, as she then was, citing essentially two grounds of appeal. The notice of appeal that can be found at the record of appeal, which I have as PDF page 8, Your Honors, which is at page, what page is that? (592), I think. Your Honors, it looks like 592, and I believe at this point it's convenient for me to indicate to the court that for the purposes of my presentation, I will be referring to the PDF page numbers as well as the actual page numbers, the blue page numbers set out at the bottom of the page for ease of navigation.
Yes.
Your Honors, the appellants, according to our understanding, is inviting the court, based on their three grounds of appeal, to allow the appeal and to order the release of the cash to the appellants. Conversely, Your Honors, the respondents are contending the reverse, that the Court of Appeal's decision is wholly correct, and as a result, this court will be invited to uphold the Court of Appeal's decision and dismiss the appeal with costs to the respondent. In that regard, Your Honors, it is our submission that the Court of Appeal's decision is clear and comprehensive, that it commends and defends itself, and therefore there is very little for me to add to it other than to rely wholly upon that judgment and recommend the following key paragraphs for Your Honor's consideration of that excellent decision delivered by the former Chief Justice. And the paragraphs which we will invite the court to consider closely are paragraphs 22 to 28, which treat with the legal aspects of seizure and how the court applied those principles of law to the facts of the case. And that these paragraphs can be found at PDF page 26, which starts on the page, the blue page number 77. The second paragraphs are 40 to 42, which treat with the jurisdiction, how the Court of Appeal dealt with the jurisdiction point as to whether or not the magistrate had the jurisdiction to grant the continued detention order. And these paragraphs 40 to 42 can be found at PDF page 33 of the record, which also is page 84, the blue page number 84 of the record. The third paragraphs are paragraphs 55 and 57 of that judgment, which treat with the lawfulness of the retention period, which can be found at PDF page 40, which is also page 91 in blue. And finally, paragraphs 58 to 63, and we would recommend in particular paragraph 62 to 63 of the judgment, which treat with the principles on reviewing an application for judicial review. That can be found at PDF page 42 of the record, which is page 93, blue. Your Honors, it is our submission that when all these key paragraphs are taken together, they satisfactorily answer all the grounds of the appeal, particularly grounds 1 and 2, and dispose of the appeal in favor of the respondents. And before we delve into the two specific grounds of appeal, It is worthwhile for the respondents to mention that this appeal is framed within the context of a judicial review application, which was filed by the appellants, challenging the decision of the magistrate to grant a continued detention order in respect of cash seized in the amount of approximately $982,000 in various currencies.
But you will agree, counsel, that one of the grounds on which judicial review can be upheld is a ground of legality. Would you agree that if the magistrate acted against the law, against the authorities, that decision can be overturned? And yes. So I gather that one of the points that Mr. Fraser is making is that at the time that Constable Jules purported to seize the raise, the raise was in the unlawful custody of the police.
Yes, sir, I understand.
I would, yeah. So, to cut to the chase, I would like to hear how you respond to that, because that sounds an interesting point to me. I know you're giving us the paragraphs from the Court of Appeals judgment, but what is your position in relation to that point?
And that is the point in relation to the period of the retention from January 1st onwards to April 23rd?
The 115 days, yes.
Your Honor, our position on this is that the court first needs to determine, which a magistrate did and the Court of Appeal upheld, firstly, as to when did the FIA officer, WPC Jules, purport to exercise the power of seizure under the POCA regulations, meaning Section 29A. And that
There's no doubt about that. Is it the date on which he purported to seize the raids is clearly indicated in the record, isn't it?
Yes, sir.
And isn't it also the case that it's agreed that prior to that date, 115 days elapsed between the discontinuation of the criminal proceedings and that date?
Yes, Your Honor.
Right. So I'm just trying to get you to respond to counsel's point that the retention of the property for that length of time was unlawful.
Well, our submission in response to that, Your Honor, begins with the authority of Derek Daniel, which can be found at, let me just confirm this. Just a minute, Your Honor, which we will submit, Your Honor. Yes, just a minute, Your Honor. My PDF seems to have just closed, so I want to reopen it. That's page 1. Yes, Your Honor, we are relying on paragraph 23 of the Derek Daniel decision, which can be found at PDF page 324, which also is page 703 of the bundle. That's the blue page number, which essentially states, Your Honor, that mere possession of property by the police or any authority does not constitute unlawful possession, but it only raises to unlawful possession where a demand has been made for the return of the item. And if an item, no demand has been made, because I believe, Your Honor, one of Your Honors would have raised the point as to whether any application had been made. And it is a relevant question, and it goes to the question of unlawfulness, because had that request, even though it was not in the form of an application for the release of the funds, but a request to the police to release the funds, and in defiance of that request, they retained it, then potentially it would arise that the police were in unlawful possession. So that's
I raised that point with Mr. Fraser, and his response was yes, he could have applied, but there was no obligation on him to apply. And it was the duty of the state, in this case the police, to return the raise after a grace period. And I think that is in fact something also accepted by the Court of Appeal, that the law enforcement authorities had a grace period within which they could keep possession, but then they had to return it. So the returning isn't to be predicated upon an application by the appellants, is it?
No, Your Honor, we are not submitting that. We are saying yes, an application could have been made, but on the authority of the Daniel decision as to what would then constitute an unlawful possession is that if a demand in the form of a request to the police, not necessarily an application to the court, but a request given to the police asking for the res to be returned, because the Derek Daniels authority is authority for the proposition that mere possession is not sufficient to give rise to unlawful possession by the police. And our second answer in relation to that period is, again, when one considers the consideration of the authority of Iqbal, along with Garney and Jones, which Garney and Jones first established the principle that the police can retain property seized, provided that there was a basis for that continued retention. And the Iqbal decision went on to say that the police were allowed to retain property for such reasonable period as was necessary to allow for further investigations or to determine what it is that they were going to do in relation to the property in question. So in this case, Your Honors, our submission has always been, and which the learned magistrate accepted, that the period of time between January 1st to April 23rd was not so unreasonable given the context of this case as to constitute an unlawful possession. And the facts which the magistrate had before her was, firstly, the amount of cash that was involved, 932,000 EC dollars and some change in various currencies, the circumstances in which it was seized, that it only came to the attention of the police that the prosecution had discontinued the matter, Your Honor. And of course, naturally, the police who would have charged the suspects would want to inquire as to why a prosecution in the value of $932,000 was discontinued. And from the affidavit evidence of Sergeant Collymore and Mr. Scholar of the FIA, they all indicated that the inquiries were made and advice was sought. Following on that, and those
go ahead, please.
WPC Jules then became involved with the FIA, and when she went on to conduct her own investigation, and which she says in paragraph 8 of her affidavit, that based on her investigations, she decided to seize the cash from Constable Allen under poker. And therefore, it was our submission today, as it was previously, that that period in time in where the police made the inquiries and was determining what legal steps they could take in relation to that property was sufficient, because as Your Honor would be aware, that very issue has occupied the attention of the courts in St Lucia since 2019, whether or not the police could lawfully keep the cash and exercise any other law enforcement power over that cash, which was seized since 2019. It's been before magistrate, the High Court, the Court of Appeal, and now the CCJ, Your Honor, on that very issue. And therefore, it is our submission that the police will exercise prudence and diligence, as the learned magistrate indicated in her decision, in determining what were they allowed to do with that cash amounting to $932,000 in these circumstances. And what we are inviting the court to accept is that period of time was adequate given the issues, the legal issues that arose in it, the amount of cash involved, and the level of complexity that the circumstances created. It wasn't just a question of let me return $10,000. Even $10,000, I would say.
Mr. Snack, do we have any evidence as to when, from what time, did
Yes.
Officer Jules or the FIA become interested in this issue?
Your Honor, yes, just give me a moment. I would want to start with the evidence from, I believe he was inspector at the time, Collimo. Just let me go to that.
Look at paragraph on page 256, Counsel, the blue letter numbering.
Yes, page 256.
256.
Just
The
allow
letter
me
to
get there.
FIA by Collymore.
Yes, Your Honor, that is, unfortunately, there were repetition of documents, so let me just get to 256. Yes, Your Honor, that is the letter sent to FIA dated 15th of April 2019, where he invites the FIA to conduct investigations into the matter, and as well, Your Honors, what he would have communicated in his affidavit to the magistrate, which the magistrate would have considered, and along with the affidavit of Inspector or Deputy Director Scholar, who's also the FIA. And if I could just the court could give me a moment to find those relevant paragraphs. Let's see, so.
And while you find that, Mr. Schnack, I take it then that the letter from the superintendent of police came on, at least it's dated the 15th of April 2019. And is it that then just Officer Jules sees the cash, according to what the respondents allege, on the 24th of April 2019?
Yes, Your Honor, from what?
A little more than what, a week, less than 2 weeks?
That's correct. When it was communicated, FIA and WPC Jules later became involved, because when we read it together with the affidavit of Mr. Scholar, he's clearly indicating that he reviewed it himself and subsequently assigned it to WPC Jules, who then went on to carry on her investigations, which culminated in the seizure on the 24th of April. And therefore, what the learned magistrate had before her was the affidavit of Superintendent Collymore, supported by his letter to the Deputy Director, and actually it's addressed to Mr. Thompson, the Director, the affidavit of Mr. Scholar, who happens to be the Deputy Director, and also the affidavit of what WPC Jules would have done subsequently. So there is no question at all, Your Honors, that WPC Jules did not act on her own suspicion, that she carried out
well, I want to pursue an issue about time and timeliness. Now, I see this letter from the Superintendent of Police to Paul Thompson. It's dated the 15th of April, but he says that he received correspondence on the 15th of March from the court indicating that the proceedings against the accused persons had been discontinued. What's the date of the discontinuance?
31st of December 2018.
18.
Okay, December 2018.
Court order was formally discontinued because if I could give an indication to the court that the notice of discontinuance was filed by the prosecution on December 31st, 2018, and the court entered the order of discontinuance formally on March, I think, 15th.
March the 5th. March the when?
5th of 2019.
March 5th. So time would begin running from March the 5th. Is that it?
Your Honor, yes, we would submit that that is one potential time period that one can use as to determine when the time should begin to run. I know my learned friend, on the other hand, would be suggesting it began to run the moment the discontinuance was filed, which took effect from January 1st.
No, well, it seems to me that, well, we could probably argue on that, but it's not unreasonable to go by the date the court actually ordered the discontinuance, because the ex parte intention of one party doesn't bring the matter to an end. It's a court order that brings it to an end. And if we accept that principle, then you say that the matter ended on March the 5th. So time starts running on March the 5th. Then on the 15th of March, the Superintendent of Police received correspondence from the court indicating that the matter had been discontinued. And on the 15th of April, it took a month, he communicated to Paul Thompson. And then when did Officer Jules effect the seizure, the supposed alleged seizure?
The 24th of April, Your Honor.
Yeah, well, I'm afraid I'm not seeing any long gap here in terms of reasonableness. From the 5th of March, then the next step is the 15th of March, where correspondence is received. And then the 15th of April, a letter is sent or a memo is sent. And then later in April, the supposed seizure is effected. Where is there? Well, I suppose I should have been asking Mr. Fraser these questions, but where is there an unreasonable gap to suggest that the police were just holding on to this money and were unconcerned about giving it back to its rightful owner, as distinct from taking reasonable steps to see what, if any, further process they needed to effect in relation to the money?
Yes, Your Honor, and hence the reason why we have maintained that the Court of Appeal was correct in upholding the magistrate's decision, where she found that the period was eminently reasonable. And I can only repeat what we've submitted so far, that given the circumstances of this case, the level of complexity on the legal issues, and we would go further to say this is the first occasion when this has arisen. And poker is known to be a piece of legislation that is replete with difficulties, and one needs to look at it closely. And when certain facts arise, one needs to assess what the legal position is. And the court would note that most of the authorities cited throughout these proceedings are authorities from the United Kingdom, who incidentally perhaps has a little more experience, as they have more cases that's come before the courts in dealing with those issues. And in St Lucia, this was the first time this has come up. And therefore, we could only submit that the police were very responsible, and we would commend them considerably in making the necessary inquiries and asking for the necessary legal advice because they would have noted this was $950,000 in various currencies, and they did not understand why it is that the prosecution was discontinued. And therefore, they got the FIA involved. The FIA did the responsible thing by not simply just acting, but did their own investigations, and they thought there was merit to seize exercising that power of seizure on the poker. And we maintain that that is when time begins to run in terms of the 72 hours, when the power of seizure on the poker, Section 29A, was exercised. And that power of seizure on the poker was exercised on April 24th, 2019. And therefore, when the continued detention order was granted on the 26th of April, it was well within the 72 hours.
Okay, so I take it you have you've submitted two arguments to in response to the claim that this money was in the unlawful possession of the police during that period. First, you say that the time span was not unreasonable. And then you also say that in any event, the money is only unlawfully retained or detained if it is being kept in defiance of a demand. And here there was no demand.
That is correct, Your Honor.
Yes, so we understand those two responses. Could you deal with the other points raised by Mr. Fraser?
Your Honor, I would have to go back to the point in relation to his ground one of his appeal as framed, Your Honor, and we would submit that the issue as to the absence of evidence of the seizure is not a valid ground of appeal, as it was never raised, or he was never granted leave to apply for judicial review on that ground. The appellant's only two fundamental issues that was raised on judicial review was whether the magistrate had jurisdiction to grant a continued detention order, as the appellants were of the view that the 72-hour time period had elapsed. They never raised and they never canvassed, whether in the High Court or in the Court of Appeal, that there was a question as to whether there was evidence of the actual seizure. And we are submitting that therefore ground one is invalid, and the court ought not to allow the appeal on this ground because it was never the subject of the appeal in the court below. And it would not be a basis on which this court could validly overturn or allow the appeal in respect of this matter, Your Honor.
If we disagreed with you on that point about the technicality of whether that is a valid ground of appeal, what do you have to say about, and without prejudice to our views on that, what do you have to say about the substance of the argument?
Well, Your Honor, we would treat with the issue as to ground one to say that there was evidence of the seizure, which the Court of Appeal accepted, and that they initially accepted the affidavit evidence of Dahlia Jules on this matter at paragraph 8 of her affidavit, where she indicated that she seized the cash from Constable Alan James. Alan James, Your Honor. And that cash was in various currencies. And she would have seized that on the 24th.
It is a metaphorical seizing.
Well, I suspect it was a little more than that, because based on how her affidavit is written, that the cash was in the possession of the police and FIA seized it from the police because of the criminal nature of the charges, how it was packaged. The police had it in that form, they had discovered it in 2010 in the back of the vehicle wrapped up in the cling film, etc. So she sees that from Constable Alan James, and it was that found its way after FIA seized it. That was what was then placed in the interest-bearing account, Your Honor. So it was a little more than mere constructive. And we would submit that because the res was in the possession of the police, the seizure could only have been effected from the police because they're the ones with possession of the property. Issuing a notice to the appellants would not have advanced the matter very far, and all the authorities indicate, Iqbal and Hickman, that assuming that the police seized from themselves, Iqbal and Hickman are indicating that is perfectly permissible. There is no issue with the police seizing from themselves under a separate statutory power of seizure, which is what occurred in this case. Constable Alan James would have seized pursuant to their criminal law powers under the criminal code, and then WPC Jules later seized on the poker legislation. And
what do you think of Mr. Fraser's request for a ceremony?
Your Honor, the authority that Mr. Fraser relies on, King, actually says quite the reverse. And if I could take you to that decision, just give me a moment, Your Honor. Your Honor, the King decision, which my learned friend relies on.
What page? What's the CCJ page number?
438 of the bundle. Yes, 438,
Sorry,
Your Honor.
438.
438, Your Honor. And I'm just going towards the latter part of that decision, towards the end. And it's a very useful decision, Your Honor, admittedly, because it deals with all the key authorities of both Hickman, Iqbal, Cook, and this particular case. And I just want to... The paragraph 38 of that decision, or at page 448, that's the blue page number. The court says, I would also reject the suggestion that what I will call the re-seizure ceremony at HMRC's offices on 23rd January was unlawful because re-seizure could only take place after the cash had been handed back to the claimants. As Philip L.J. pointed out in Iqbal, that was only required in the Cook case because the original seizure had been unlawful. If re-seizure was lawful in principle, as I consider that it would be nonsensical to suppose that the £400,000 in banknotes had to be brought to KCL's premises with the obvious attendant security risk for the ceremony to take place. So, Your Honor, the authority of King is saying quite the reverse. We note that the amount in this case in the £100,000 in bank currencies, while it's somewhat more than 952,000 EC dollars, it remains true that that is 950,000 Eastern Caribbean dollars when it was placed in the bank, or at least $950,000 in various currencies, that the appellant is suggesting in order to infuse that re-seizure with lawfulness, they had to return it to the appellants and have that ceremony. I think in fairness,
Mr. Fraser's point, his premise is that at the time the supposed seizure was effected, that it was in the unlawful possession of the police. In other words, he's using this case on the basis that the police were in unlawful possession. if the police were not in unlawful possession, I don't believe that he would have made this argument. So the two things are tied up.
Yes, Your Honor, and I suspect, and forgive me if I'm mistaken on this, that my learned friend is suggesting that the possession by the police, they were in unlawful possession. So in order to regularize that unlawful possession, they had to return it to the appellants.
That's my understanding.
I do not read paragraph 38 to be suggesting that in such a case where there's $400,000, £400,000, that it was sensible to adopt that approach, because in Cook, it appeared, if I recall correctly, these were items of property and not cash that was considered in Cook, and why it would make sense to simply hand back the physical property. But at paragraph 38 of King, I would submit to the court, it is suggesting that while Cook said you had to return the property, but it is nonsensical in the case of £400,000 for the obvious security risks, Your Honor. And it is important to make the point that Cook decided that the police could not reseize from themselves because the original seizure was unlawful. But this is not the case here at all, because what is the original seizure? The original seizure occurred by Constable Alan James for the offense of unlawful possession in 2010 when they stopped the vehicle on Clark Street, Viewford, and found the these currencies wrapped in the manner that they were. And then they seized the cash. And they had every lawful authority to do so because it led to criminal charges. That is the original seizure.
I don't think there's any dispute about that. I think the only the entry of unlawfulness is what has been argued is the undue delay in retention, the retention period post discontinuance. So I don't think there is any question. And the case is properly, as you have pointed out, different on that basis. So yeah.
And yes, Your Honor, and therefore that would be part of our answer to that the King authority is suggesting. One, we were saying they were in lawful possession, they did not have to return it. And if the court were to find that that period between January 1, 2019 to April 23rd, 2019 in some way was unlawful, we are submitting that given how we read paragraph 38 of King, and given the amount of currency.
But in this case, isn't there also the aspect that even though Jules happened to be a police officer, in fact, this is a different agency seizing. This is not a police re-seizing. This is a different unit, the financial, is it FIU, who are executing this seizure in the exercise of an original, when I say original, a statutory jurisdiction under the Proceeds of Crime Act. Is that not so?
Absolutely correct, Your Honor.
Yeah. So whatever happened with the first seizure was lawful, not challenged. That's under the criminal law. Those proceedings are discontinued. Then under the Proceeds of Crime Act, an investigating officer, properly constituted, nobody challenges that, executes a seizure of, as is in this case, cash that happens to be in the possession of the police. Yeah.
Yes, Your Honor. And
yeah. So academically, does it matter whether it was in the possession of the police unlawfully? If this is, yeah, sorry, go on.
It is our submission that it would not, and we would have invited the court to consider it, and we are happy that the court has raised it by distinguishing what occurred in Cook as opposed to what occurred in this case, because the Cook decision was where the police were receiving from themselves, and because they were initial unlawful possession, before they could exercise their powers again, they had to restore the res to the defendants. But this is not what occurred here. what occurred here
Jules,
is that
Jules could have gone to any place where such monies were believed to have been held and exercise the powers under the Proceeds of Crime Act, but would have had to meet the statutory requirements of reasonable suspicion and brought it within the timeline of 72 hours, correct?
Correct, Your Honor.
Yeah, okay, good, thanks.
So we're saying that even if the court were to find that the police were in unlawful possession, it did not preclude WPC Jules of the FIA from exercising her reasonable suspicion and exercising her statutory power under Section 29A to seize the cash, because the lawfulness of her actions we are submitting is not tainted by the otherwise alleged unlawful possession of the police, because it is WPC Jules acting as a financial investigator of the FIA and exercising her powers as a financial investigator as granted to her by law.
You're going a bit beyond the Court of Appeal, though, aren't you? Because the Court of Appeal did say that that is one of the factors that could be considered by the magistrate in deciding on the detention order. It's within the scope of her discretion, but the fact that the property was being held unlawful, if that was a fact, which is of course debatable, that unlawful retention is something that the magistrate could have considered in deciding whether to give that detention order. Am I right?
Correct, Your Honor, and we are submitting that was the correct approach to take in a judicial review application, which was now on appeal, to review whether, not that them, as Your Lordship would have, I think it's Your Honor, Madam Justice Green, who indicated that what was the court allowed to do in a judicial review application, not to determine so much the correctness or whether we agreed or whether we would have come to that same decision, but whether it was open to the magistrate based on the facts available to her to arrive at a decision that she did. And we are submitting that the Court of Appeal accepted that there was evidence to support without irrationality the magistrate's decision, and therefore it was not open to the court to substitute its own view of the facts as the learned trial judge had done. And we are maintaining that that is the proper approach for this court to take, and find that based on the available evidence, it was open to the magistrate to find that the period in which the police retained the cash was not unlawful. And I would go a step further, because Your Honor would have raised that it goes somewhat beyond what the Court of Appeal would have said. But in line of the new authority that my learned friend has relied upon in King, which also raises the case of Cook, and to support his argument that the unlawful possession by the police deprives them of the ability to reseize, then we are compelled to make the point that, well, it's distinguishable because this is not what happened here. It is the FIA who seized, and why the appeal decision, and perhaps why the High Court judge himself strayed into discussing whether WPC Jules was an officer of the police or not. But the fact remains that WPC was Jules was a financial investigator seizing under her powers as a financial investigator of the FIA.
Good, thanks.
And Beloved, I would submit in addition to what my learned friend would have submitted in relation to the short period of grace after the discontinuance to apply for the continued detention order, 2 points. The first is that as the case is decided, in particular Iqbal and what the Court of Appeal would have accepted, that short period of grace has to be assessed in the context of the factual circumstances. It cannot be given a fixed time period, as my learned friend is suggesting, of say perhaps a month. And we would submit that would be wrong in law and would subject the police to and the FIA themselves to too stringent a timeline in an area of law which is notoriously complex. That is cash seizure, confiscation of assets, etc. And 1 month would probably be insufficient for all the law enforcement authorities to discuss and make inquiries and to investigate and to get legal advice. And so we would submit that that short period of time has to be construed in terms of what is reasonable in each individual case, and that I would end there on each individual case, and to move to the second aspect of my submission on this point, that my learned friends seem to have suggested that that period of time, which was a short period of grace before they had to apply for continued detention order, I would submit that that is somewhat misleading, because that period of time where it is in the possession of the police, they are not yet in a position to apply for continued detention order. That only arises when either the police or the FIA officer has exercised the power of seizure under Section 29A. And it's only when they have exercised that seizure power on the POCA, Section 29A, that they now have to apply for continued detention order. Your Honors, I believe I would have addressed substantially the 2 grounds of appeal that that arise on this appeal. I believe I would like to make a few additional points. I just want to go through my notes, Your Honors, see where it is that I need to address the court. We could have a few minutes, Your Honor. Your Honor, a few additional points that we would like to raise to the court. We would like briefly just to refer to the procurator case that my learned friend relied upon, to simply submit that it is not a terribly helpful authority, and it is of little assistance in disposing of this appeal, as it essentially decided that seizure did not have to be physical. And the court would note the vintage of that case, I believe it's 1917, where the court agreed where vessels were seized during a period of war, and they indicated that seizure did not have to be physical, but that in that case, it was the seizure had been effected by a mere agreement between the parties. To simply submit that being the case, it supports the respondent's position that there was no physical taking of the errors in this case from the appellants, but the seizure had been effected.
Unless I misunderstood him, I think Mr. Fraser conceded that point, that there could be constructive seizure.
Your Honor, I would just want to, for the avoidance of any issues, draw to the court's attention the appellant's reply arguments on the amendment as to whether the respondents had amended the application for the continued detention order to replace the name of the Commissioner of Police with that of WPC Jules. And we would refer the court to paragraph 4 of Magistrate Reynolds' affidavit. Let me just find that.
So there was an oral application which
Yes,
was approved, right? And the other side is saying that there isn't anything in the record of appeal and documents aside from the affidavits of the two persons, the magistrate and the constable, to that effect. So, in a sense, I'm not sure that there's any necessary conflict. There's an oral application and it's approved orally, but there isn't an order. And I don't think Mr. Fraser was the attorney present at the time.
No, it
Somebody,
was the Honorable Leslie Mondesi, who was in private practice at that time.
Exactly. So, yeah, so Mr. Fraser wouldn't have known. I assume.
But Your Honor, the only reason we want to ensure clarity on this point, that the application for the amendment was made and granted, but as we understood the manner in which the appellants have prosecuted the application for judicial review was that they maintained that there was no amendment, that it was the commissioner of the police who applied for the continued detention order. The seizure was made from himself. He could not, and under their understanding of the law, the police could not reseize from themselves, and Constable Jules was therefore acting under the direction of the commissioner of police, and she did not have that reasonable suspicion, etc., etc. That's how his arguments unfolded, which is why we just wanted to draw to the court's attention that there was this oral application which was made and granted, and it was, and as indicated by WPC Jules, the prosecutor at the time in the magistrate's court was advised to do this, and it is consistent with the arguments raised by the respondents in this appeal.
Yeah. We follow you.
Thank you, Your Honor. Your Honor, I come finally, we'll make 2 points, what we'll call the residual discretion point, and the last, which is to address ground 3 of my learned friend's appeal, which is the matter of cost. We don't propose to make oral submissions of this, but to rely on our submissions. But in respect of the residual discretion point, which we would have raised in the High Court and in relation to, as well as in the Court of Appeal, and we accept that neither of the courts ruled on this because it did not necessarily arise or to determine the appeal. But however, we still believe that it is a point worth taking because it is a matter of some significance as it will impact the law. And we would invite the court to consider our submissions at paragraph 26 of our submissions. And we submit, Your Honor, that whilst we accept that generally the starting point is where items are found to be unlawfully seized by the police, they are to be returned to the defendants, whoever was in possessory, whoever had the possessory title at that time. However, we are relying on the authority of Gao, which can be found at page 599 of the bundle. Let me just go to that. And in particular, the paragraphs, which can be found at page 613. Just give me a moment, Your Honor, I'm sorry. And in particular, paragraphs 41, correct, yes, sorry, 42, Roman numeral 2, and paragraph 48 of GAL, which internally my colleague and I refer to as the rebarbative point, because the learned judge used a very interesting adjective, rebarbative, of first time discovery, so we call it the rebarbative point as to whether the court should, if property is found to be unlawfully seized, should they always grant the relief of returning that property to the persons in possessory title of it. And the court, whilst my learned friend is submitting that it does not yet form part of the common law, their lordships in that case raised it as a potential issue. And the reason why, and they did not come up for decision in that case, but they saw it as a potential issue that the court will in future have to determine. And this case, Your Honors, we are submitting does present such an issue, and whether or not a court would grant the return or restitution of property in circumstances which, to use the learned judge's expression, rebarbative, we are submitting that in this case, in circumstances where money is wrapped in the manner that it was, in the circumstances it was discovered at night at Viewfort at the back of a vehicle wrapped up, and there is no explanation as to how the person's possessory title came to be in possession of it, then it is open to the court whether in their discretion they ought properly to return the cash to these persons. And to quote what Lord Justice Carnwath, and I understand he later went all the way up to the Supreme Court in the United Kingdom, where he says in paragraph 48, I find it inherently rebarbative that a person may be held entitled to recover and continue to enjoy property, even though the court may be satisfied that he is not the owner and has acquired the property illegally. The magistrate may well not be obliged to make an order in favor of such a claimant. And the reason why we are making this submission, because it's entirely sensible, and we would submit that the justice system has to take note of the realities that occur in our respective countries, and how perhaps decisions, because as famously said, justice must be done, but must also be seen to be done. And persons in the community who may come to their attention at over $932,000 was returned to persons who had no explanation as to how it came, whether that would inspire confidence in the justice system, that is the confidence in our decision makers, and whether simply because the supposed retention period where the police were inquiring into what they should do with this currency, the court would order that money to be returned to them, whilst the respondents would be prepared to accept that whether the Crown has failed to satisfy the legal requirements for forfeiture, they too may not necessarily earn the right to retain those funds, but the court could, in its discretion, direct where those funds are to be allocated or where it is to go. We have very many charitable organizations who are in need of funds and that would only be too happy to get that type of money or that amount of money, Your Honors. And And I make this submission in all seriousness, and I would invite the court to consider it closely as to whether, in all circumstances, a magistrate or court is bound to return the res to persons found in possession of it.
Counsel, you may be overreaching, and I thought it was tongue-in-cheek rather than in all seriousness. In the case that you cited, the rebarbative case, the statement was where the court was satisfied as to certain things. In this instance, nobody is satisfied as to anything, although it may well be stated that there is some ground for suspicion. So, yeah, let's leave it there.
Very well, Madam. And that takes us to my last point, Your Honor, in relation to the cost order and our submissions on that point. Just a minute, Your Honor. 569 of the bundle, where we raise the matter of, we argue the position as to cost, and we rely on our submissions in respect of that ground of appeal. Your Honor, I thank you for your time, and these are the extent of our submissions of the respondents, and if we can assist the court on any other issue, we'll be happy to do so.
Thank you. Mr. Fraser, do you have a reply to make?
Yes, Your Honor. Brief submissions. The first one is that the case of Derek Daniels that my learned colleague seeks to rely on is not applicable to the matter before the court. That's a case of detention, and the law is clear: to sustain the thought of detention, you must make a demand. Failure to make the demand, you wouldn't have a case that can be sustained. That has nothing to do with matters falling under POCA legislation. So it's not inappropriate.
There's something under the POCA legislation that specifically says that if property is seized and the case is dismissed, that there is an obligation to return the property immediately.
It says there's an obligation to return it, and to use the words of the section 22, to retain it as long as is necessary in all of the circumstances.
Good. So that
is what it says.
When you spoke earlier about the enormity of the length of 115 days, did you factor the points that were raised by Mr. Sinak, the novelty of POCA legislation, the amount of cash, the fact that that this cash was found, how it was found, where it was found, and also, you initially gave us the impression that, well, I got the impression that over those 115 days, the respondents, police, FIA, whoever, were simply dithering. But that is not the case. When you look at the various steps that were taken, the interval, and those steps were reasonable, rational, were I don't see that anyone can fault the taking of those steps. The interval between those steps, can that interval or those intervals be said to be unreasonable? 31st of December, dismissal of the action, but no order is made. The 5th of March, an order is made, discontinuing the matter. The 15th of March, there is communication received by the police from the court. The 15th of April, the police send a memo to the FIA, and the funds were seized on the 24th of April. Is that correct?
Yes, Your Honor.
Yeah, well,
Your Honor,
those,
the thing about the Section 29A of the legislation does not read the way Section 22 of base reads. It doesn't say anything to do with how long the police can hold the currency. All it provides is for the period of seizure being 72 hours to come to the court to have the continued detention order.
no, but we are not concerned
Mr. Fraser,
with the time of seizures yet.
But President, is that seizure by the police or under the Proceeds of Crime Act?
Under the Poker Act. Under the
Right.
Poker Act.
Right.
So what we're saying is that we in St Lucia will be governed by the common law. What was held in Malone and Ghani, that you cannot be you cannot continue retaining because you're speculating as to what to do and whether there is any proceedings that you can bring for forfeiture. And this is the case here. The courts frowned upon that reason. And when you looked at ASP Colin Moore's affidavit, it reeks of the fact that all they were trying to do is to ascertain what to do, leading to forfeiture. He talks about making phone calls.
Let us assume that they were doing that. Given the context, was that even unreasonable?
As I said, even if we go with what Section 22 says, and Iqbal says that grace period, short grace period, even though the legislation says you can hold it as long as it's necessary in the circumstances. They said the grace period must be short. So we can't run out from under poker. The courts are saying it must be short. Under the common law, Malone and Ghani, they're saying you can't retain to speculate about forfeiture proceedings. And this is what the police were doing. They received notice of discontinuance on the 4th of January. The officer said he made telephone calls. And if he's made telephone calls, he would have received information immediately concerning all of these things that he says, the reason why they're withdrawing and all of that. He didn't say who they were speaking to, but he made telephone calls. And one would have to believe that he got information that he needed. So when you look at the circumstances, what they were doing is not pursuing an investigation. They are mulling the return of the currency because they wanted to invoke some proceedings. The law from on that. We governed by Malone and Ghani. And even if you borrow from Iqbal, it defies the short grace period. And this is our contention.
Yes, the Court of Appeal, though, was of the view that even if you were right, and of course they didn't think that you were, but even if you were right, then the unlawful retention of the cash was something that the magistrate could have considered, should have considered, in deciding whether to grant the detention order. In other words, the mere fact that you have established that the cash was kept too long, assuming you have established that is to be debated, but the mere fact you establish that does not necessarily follow that the cash cannot then be seized by the FIA, does it?
We are saying that the cash was held unlawfully. And so that calls into question the subsequent seizure by the FIA.
How?
Because it was seized from an unlawful source. We made that point. And we made that point based on the authorities that we put before.
When you say there's a problem with this, and Justice Chairman, I was raising it. When you say an unlawful source, isn't the FIA entitled to seize stuff, cash, whatever that they consider contravenes the relevant legislation, wherever they find
In
that.
St Lucia?
Without a doubt, that is what they are authorized to do, beloved.
So does it matter whether the previous holder was in unlawful possession of the cash or not?
We are governed by the authorities, which clearly says that when the FIA purported to seize, they were seizing from a source that was unlawful, who was holding the cash unlawfully.
Now, my question is there something that says that they can't seize cash from what you call an unlawful source if, in fact, they have reasonable suspicion to think that that cash contravenes the legislation under which they are acting?
We will go with the context in which the case is found out. What we have is an initial seizure in 2010, May of 2010.
By one arm of the state?
By one arm of the state.
Yes.
Then there's been a discontinuance.
Yes.
At that juncture, the law kicks in that the possessory right of the appellants must be given effect to.
Sorry, Mr. Fraser, I think the president had already established there was a discontinuance, but there was not an order. And the president established that that was made on the 5th of March.
Yes, I will come to that, Your Honor.
I see.
I will come to that.
Okay.
I'll address that separately. So we're saying that when that operation kicks in, then in order to retain the currency, you have to have a justification for so doing. And the law is clear.
That's the arm that initially confiscated it.
Yes. So our contention is that there is no separation between FIA and the police in this regard.
That is what you suggest.
So we're saying when Constable Jules purported to seize, she was acting as police, and the whole intention was she was acting as police officer.
Now you see why Mr. Senak was so very keen to draw the distinction between the role being played by Constable Woman Jules, because in relation to the seizure, she's acting as an agent of the FIA. And as you heard, we had the discussion earlier, amendments were made to ensure that the proceedings were being brought not by the Commissioner of Police, but by the FIA.
Well, as I made the point, my lord, that was not borne out by the evidence that was before the court.
You're not questioning
and of course, I was not present when this.
You're not questioning the affidavit of the magistrate, are you?
No, I was not present when this alleged amendment was made. But I was going on what was before the court and what we have.
But if you were to accept, if you were counsel to accept that the amendment was made and that she was acting on behalf of the FIA as a financial investigator, would your position not be different?
No, my lord. I believe she's in no different position. I believe the FIA is not in any different position from a police officer seeking to reseize in the circumstances.
Okay.
Because they're all agents of the crown.
But is it relevant that although they are all agents of the crown, the constituent document and the legislative regime that governs their acts is different? You say all of them is police, so it's just one thing. And someone else says, yes, they're all police, but they're in different agencies. And the legislative regime that governs one is not identical to the legislative regime that governs the other. And therefore, you can't really say they all one. And I'm not making a distinction. All of them is police. How do you respond to that?
I'm just merely saying, Your Honor, that I don't think FNI is in any different position in relation to the unlawful retention by the police.
No, but
they don't get a clean bill of right to seize
But in this
outside of...
context, retention is a funny word because FIA never had the property before Jules says she seized it. So
No, they
FIA
never.
wasn't retaining anything.
Yes, but my lord, you see, the distinction I want to make is the fact that the possessory right that the appellants had was being defeated by what is taking place by the police and then subsequently
Yes,
FIA.
and the FIA said it was properly being defeated.
And in the round, the FIA could not divorce itself from what the police have done in relation to defeating that possessory right that the appellants have. That is my contention.
Yeah.
Next point I want to raise, Your Honors, is Section 72 of the Constitution gives the authority of the DPP the sole discretion to discontinue proceedings. And this is what he did on the 31st of December 2018. When he filed that nolli-pros document, he had effectively put an end to the proceedings. And that is why time started to run from the time that document was entered into the court. I hear the court that when the court gives blessings to the nolli-pros in March, that's when the court made the order. But to me, the effective withdrawal of the case was when the DPP filed it. Because the authority is his, not the court. The court just gives blessings to what the DPP wanted to achieve. And so I would believe effectively time started to run from the 31st, from the first rather, after that document was filed. Next point I want to raise, Your Honor, is I'm deeply troubled that my learned friend says that the question of the seizure was not raised in any of the courts below. That is not so. I pointed to the court to paragraph 2.22 of the appellant submissions and refer the court to the skeleton arguments in the High Court at paragraph 3 to 3.3, where that's the supplemental record of appeal. It's in the supplemental record of appeal, where that issue was canvassed before the learned trial judge. He did not deal with it. He made no rulings on it, but it was canvassed, brought before him, and argued. The Court of Appeal erroneously said it was not argued, but nevertheless, they choose to deal with the issue at paragraph 22 onwards. So when my friend said this issue was not before the court, that is not true. It was in both courts. Next point, my lords, is the fact that I heard my colleague giving evidence on the bar table to suggest that the currency was in the possession of the police, physical possession of the police, at the time when this purported seizure was made. And that the only time that the currency ended up in the bank is after that. That is not so. We argued this case in the courts below that the currency was not available because it was in the bank, and it was in the bank during the criminal process. We know that. And we argue that, and counsel never refuted that fact. They made submissions on it. I think it was accepted by the Court of Appeal. What we were dealing with was a constructive seizure. And that was so because it accepted the fact that we were saying that the money was in the bank, and so therefore Constable Jules could not physically seize it, and or seizure had to be constructed. So I don't know why my colleague is now coming to say now, after accepting that that premise, come to say now that somehow Constable Jules had physical custody of the res on the 24th of April. And lastly, my lord, my colleagues suggesting that once the criminal proceedings were discontinued without a conviction, if the res was lawfully seized, it does not have to be returned. That is what I think I heard him say. But that is not the law. Once the criminal proceedings are discontinued, the law is clear that it should be returned to the person from whom it was seized.
Mr. Fraser, what is the actual mechanism of return? Is it that the police then calls you in and hands it over, or mails the property to you, or ships it to you, or whatever? Or is it that the person comes to the police and says, look, my property, my case has been dismissed. This is the court order. I would like to get back my property. What's the actual mechanism?
As I indicated, my lord, there is no onus on the appellants to do that. I take it that it makes no sense to take that quantity of money and actually hand it over to the appellants and then ask it back. What we're saying that there ought to be some formal official ceremony, so to speak, where
that's the
something is done.
You're talking about
the rescission.
No,
something is done.
I'm not on the rescission.
Very well.
I'm on the return. You said that once the process had been entered, the police became under an obligation to return the res. And I'm asking you, what is the ceremony, to use your word, involved in this return? Is it that the police ships it to the party that they took it from, mails it to them, sends it to them, calls them up and tell them, hey, your case has been dismissed, come and get your money? Or is it that the person of their own volition, knowing that the case has been dismissed, turns up at the police station and says, my case has been dismissed, can you kindly give me back the stuff that you seized from me?
My lord, I think I was referring to the question of the receipt. That is why I got you wrong, because I never looked at the question of how it should be returned, because that's a matter for the police as to how they're going to return it.
No, but you see,
whether they're going to return the cash itself.
It is relevant in this context. If it is that the return process involves the former accused coming to the station to retrieve their property, and here there is no evidence that they did so, then can't an inference be drawn that, well, the police is waiting for you to come and retrieve your property, but you haven't come?
No, my lord. I don't think that can be drawn at all. Because to draw that inference would mean there is a duty on the appellants to do something, and failing to do that duty.
Can we explore this from a slightly different angle? Forget this case. In a normal case where you have the police holding somebody's property and the case is dismissed or discontinued, what happens? This is not an unusual occurrence. What happens day in, day out in the magistrate's court, in the criminal court? What happens?
Usually, Your Honor, there is some order from the magistrate or the judge to return restitution, as we say.
So the magistrate or the judge will make an order directing that the money or the bicycle be returned to the accused, correct? To the defendant, as the case may be. Right, okay. And then that order having been made, it is for the party who owns the property to turn up, I'm assuming, at the clerk to the magistrates and say, I've come to collect my whatever it is. or do you go to the police, what do you call it, the pound? Where do you go to the magistrate's court, or you go to the police where they keep the stuff? Where do you usually go?
Usually, the matter is with the police unless there's a trial.
Right. Okay.
And it's introduced as evidence. If it's introduced as evidence, it will be in the precincts of the court.
Right.
So usually it would be the police. So you turn up at the police and claim the property. That is usually what will happen.
Okay. And now what happens if the magistrate in the normal case does not make the order for restitution? Because that may happen sometimes. What happens?
I want to believe if there is inaction on the part of the police, it is open to the persons who are having an interest in the matter, maybe to file an application. And
or
say
to turn up and say, look,
and claim it.
You would get an extract from the magistrate's book showing the order and say that this and claim it, yeah? Yes. Or make an application to claim it, yeah.
That's open to the persons who have an interest in the property.
So in this case, that normal procedure would have applied. Whichever way
it could have been. It could have been.
Mm-hmm. Yeah. Because no order for restitution was made after the null pros.
None was made.
None was made by the court, right? Yeah. Okay. Yeah, thanks.
That'll be all for me, Your Honors, concerning my replies.
Yes, well, thank you. Thank you very much. And thank you, Mr. Sinak. We'll take time to consider.
Sorry, President, before we close, may I just invite Mr. Sinak? Next time, sir, you may want to allow us to see your features more distinctly. This broad angle that you have where there are three of you, none of you really decipherable. I don't find appealing, but you may be reticent about your features, and therefore I leave it for you. Thank you.
We can also confirm, though, that your voice was very, very well heard, and we appreciate that.
Thank you, Your Honor. We will certainly rectify on the next occasion, but we certainly didn't want to offend the court with our countenance, so we.
Well done.
Yes.
Thank you, Your Honor.
Okay, so we, as I said, we'll let you know when we are in a position to give a judgment on this matter. Sometimes what we do is to make an order and then give the reasons at a subsequent date. But in any event, we would let you know. Madam Deputy Registrar, you may close the proceedings.
Thank you so very much, President Saunders. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnatli. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Yamada. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Good day.
Good day.
Thank you. Good day.